And we'll move on to authentication. And Judge Palmer, I believe, is online, but we've had some technical difficulties located. So Paul is going to cover this. And Paul actually wrote a really good document that we use that talks about how to properly authenticate all of these different forms of ESI. And I will go ahead and speak for Judge Palmer, as she and I were talking a couple of days ago, getting ready for this. And the first form of authentication of any form of ESI, any form of evidence, is obviously to go through asking about it in interrogatories and request for reduction and in depositions. And if you're concerned about getting proper authentication through those resources, then there are other more advanced ways that Paul's going to discuss.
Yeah, and it may be kind of odd to talk about authentication in the context of malpractice, but again, go back to what ultimately you are trying to do for your client is quite often, represent them in some sort of adversarial proceeding, and in the course of that, you've got to get your evidence in, and I think we're beginning to see pretty clearly now the fallout that you could face as an attorney by failing to do that.
Or make sure that the other side is getting something in that is in fact authentic.
Absolutely, being able to test the other side's evidence, absolutely. One of the resources that to me is the starting point, in addition to the rules of evidence that apply to your proceeding, is an opinion by Judge Paul Grimm called Lorraine versus Merkel American Insurance. And the context in which that opinion is written is very fitting for our current discussion. It's a case in which you had cross motions for summary judgment, and essentially what Judge Grimm did is, well, first of all, let me back up again. The parties did what a lot of us have done. They wrote their brief, they attached exhibits, which were emails and letters and documents, and said, see, Judge, this email says this and this letter says this, and both parties submitted it. And what Judge Grimm did is said, nobody's authenticated any of this. You attached an email as an exhibit to a brief. You haven't authenticated the email. Judge Grimm dismissed or denied both motions for summary judgment with leave to refile. So while there probably has not been any sort of risk of any of the counsel involved in that case for malpractice, you can imagine it's still a very unpleasant conversation to have with your client. So I think we want to lump in not just avoiding malpractice here, but also avoiding some very uncomfortable and unpleasant phone calls that you may have to make, because obviously there's the issue of whether the client's going to have to pay for all that was for naught after stumbling over something that Judge Grimm points out in the opinion is as basic as authentication. But ESI does kind of make us drop back and rethink authentication a little bit. It used to be that you took the letter and you slid it across the table to the deponent and asked, do you recognize this? Yes, that's the letter I wrote to so-and-so on this date. Boom, it's authenticated. From the very beginning, in dealing with evidence, you need to rethink authentication start to finish to make sure that you preserve that evidence over time so that when you introduce it in the proceeding, you can show that it is what you purport it to be and it has not changed in any significant way since the relevant time period. The Lorraine opinion is a lengthy opinion. Depending on the format, it's anywhere from 40 to 75 pages, but it's very compartmentalized in that what Judge Grimm does after a discussion of authentication in general and some of the technology involved in general, he has individual sections on various types of electronic evidence and some ways to authenticate that. And the little cheat sheet that I've prepared is essentially just a distillation of those sections of the Lorraine opinion. But if you have various types of the common evidence that we have, emails and text messages come up. I know Judge Palmer deals with these a lot. Anyone who does criminal work deals with these a lot. But they're going to be an issue in almost every single case. We've talked a lot about video and about pictures. Any online documents, maybe you're going to prove damages. And the information you would use to prove damages are things like your credit card statements, your bank account statements, your paycheck remittance now may be online. Can you authenticate all that for your client? website material. It goes on and on. So know and be thinking about from the start how to authenticate these. Again, it can be low tech for a couple of reasons. One, the opposing party may have the same issue. And you may want to get with the opposing party if it's a low volume case. Most of the cases we all handle are still just a couple of dozen documents or maybe a couple of hundred documents. Talk to the opposing party early on. Can we agree to just print emails? Can we agree to take screenshots of website content? Can we agree that a photograph of a text on a cell phone showing the party that sent it and who they sent it to and the time is sufficient? Get as much of this done through agreement as you can. Then go on to maybe increasingly sophisticated routes. The other reason I kind of drop back to low tech is, again, what's reasonable from a malpractice standpoint may very well be influenced by the proportionality analysis that's provided in Rule 26 in both the state and federal rules regarding the scope of discovery. When it is a small case with parties with limited resources, such as a lot of divorce cases, a lot of criminal cases, it's going to be a lot harder to justify that the standard that had to be met was to have a forensic computer examiner come in and collect all this in a what some people call forensically sound manner. I think a better term is forensically defensible, because that's going to change from circumstances to circumstances. So with the proportionality analysis that's in Rule 26, that can affect how you approach this from the outset. But again, it's analysis you need to go through with each and every case and each and every bit of evidence that may come in or that you may be confronting on the other side and testing through the course of deposition or other mechanisms.
And I'll add in too, I know there was a young attorney in Minnesota I heard about a couple years ago that had a smoking gun email from their client, evidence, and the attorney himself went in and they changed it. And again, it's very easy to authenticate the original email. And go ahead.
Yeah, the room for and the temptation for malfeasance on the part of both parties and lawyers is greatly increased with digital evidence and things that you think you can accomplish by the stroke of a key or a click of a mouse.
Well, we've reached the end of our program. It's about 5:30 now, and so just a couple of housekeeping items to remind everybody about the December 1st program. On December 1st, 2015, the new federal rules go into effect. We will be hosting a 90-minute CLE. It will be live on-site here at Baltimore Bingham in Birmingham, and Judge Putnam, again, will be speaking along with Star Turner Drum, who is also a new speaker to the roundtable this year, and you can register online. Please be sure to go and fill out the survey. If you're on WebEx, I have a record of your attendance through the WebEx tool itself. And I know there are multiple people at each location, so please make sure everyone gets access to that survey to complete that for us. Let us know what you thought. Let us know what kind of topics you'd like for us to hear about, because the roundtable is here for you. We produce programs on topics that you need to know and you need to understand and deliver those with practical application for you. And thanks for your attendance today, and we look forward to seeing you on December 1st.